if the parties do contemplate the possibility of an intervening circumstance which might affect the performance of the contract, but expressly stipulate that the contract would stand despite such circumstance. Now it is the opposite situation where the parties had agreed beforehand that if such and such eventuality happens, the contract will still continue. If there is such an express provision in the contract itself that despite the eventuality the contract will continue, then obviously the contract will continue. And in such a case, there can be no frustration because the basis of the contract being to demand performance despite the happening of a particular event, and therefore it cannot disappear when that event happens. The contract will continue if there is an express provision. So both ways, if there is an express provision in the contract that on the happening of this circumstance, the contract will come to an end, then the contract will come to an end because of the contract itself, section 56 will not be applicable. On the other hand, if the contract provided that despite the happening of the event, of the eventuality, the contract will continue, then also section 56 cannot bring that contract to an end on the happening of that eventuality. But if the contract is silent, then it is for the court to decide whether on the happening of change of circumstances, the contract has come to an end or not.